This is episode 640 of the Rio Grande Foundation's Tipping Point, New Mexico. I'm Paul Gessing, president of the Rio Grande Foundation, New Mexico's free market think tank. You can find out more about the foundation at riograndefoundation.org. I am very pleased to have David Osborne of the Pennsylvania-based Commonwealth Foundation join us for this episode. David is Senior Fellow of Labor Policy there. He co-authored a report called The Battle for Worker Freedom, Grading State Public Sector Labor Laws. He authored that with Andrew Holman, who was a policy analyst, and that report came out in September of 2024. Now, as a quick aside, we got to chat briefly in Phoenix at the recent State Policy Network event and the annual meeting there, and was pleased to be a part of a group about 20, 30 folks who sat down and heard you guys go over a lot of the details in this report. But welcome to Tipping Point, New Mexico, David.
Thanks for having me on, Paul.
Yeah, so before we get into the report, you are in right now what I would consider the epicenter of American politics, at least so far as the presidential election is concerned. Now, where are you physically? I know Commonwealth, I believe, is in Harrisburg, but are
Yeah.
you in the mothership there in the home office? And what's it like just with so much attention being focused on what arguably is the most important race or state in the presidential race?
Well, we're kind of used to it, Paul. Pennsylvania has really been an important place for national politics recently. We see it as our job in Harrisburg to sort of condition the electorate here in Pennsylvania, not so that we can influence the presidential election, so that we can get them used to good policy and good politics right here on the state level. And we feel like that's important because, number one, you can actually get something done on the state level in a way that you can't do it on the federal level. And I know that in part because I served as a part-time employee for the Trump administration. It's very difficult to get anything done to the degree that you can. The next guy who's going to come into office will reverse a lot of it. So most of the gains that you can actually get and maintain are on the state level. And that's why, for instance, the report we're going to be talking about today is focused on state level policy, not on national policy.
Yeah, exactly. We will be focusing on laws. Of course, presidential politics cannot be underestimated in the area that we're talking about, because the U.S. Supreme Court, I would say, is the most recent actor when it comes to dramatically altering the balance of power with some of these public sector labor unions and labor laws, and that Janus ruling had a tremendous impact on that. So why don't we enter the report starting with that, talking about the Janus decision and how it reframed public sector labor laws in this country.
Okay, yeah. Well, Janus versus AFSCME did have a major impact, but I feel like we should probably go back a few years because the Janus case, which listeners may not know a whole lot about, really had to do with undoing some very important and unfortunately very harmful aspects of labor law that existed for decades before that. And those policies really resulted from decades of practice in the public sector, in the private sector. In private sector unions, for a very long time, mostly unregulated, unions would require either members to pay dues, or they would require, if someone refused to be a member of the union, they'd require them to pay a fee as a condition of employment. So, and many times that fee was almost the same amount as union dues, which meant a lot of people chose to become union members, knowing that they were only going to pay slightly less and they may get some benefits, even just benefits that they would have otherwise been entitled to, but the union would treat them in a very extra special way if they were dues paying members. So that existed for decades, and then unions tried to import that idea into the public sector. When we're talking public sector, we're talking teachers, we're talking cops and firefighters, state and local workers, the clerk of the court, that kind of person. And so it became a requirement in many places, with one case in particular called Abood in the 70s in Detroit, Michigan, to require non-members of the union. They had a right not to become a member, but if they were going to become a non-member, then they would have to pay a fee as a condition of employment. And in many places, they called this a fair share fee on the union premise that in order to float the finances of the union that was representing you, you'd have to pay a fee, even if you didn't like the union, even if you didn't want to become a member, even if you didn't want to subsidize them. If you were going to work there, you had to pay a fee. So that was kind of the law for a very long time, and the U.S. Supreme Court signed off on it in large part in a case called Abood in the 1970s in Detroit, which I mentioned. It was only decades later that this thing started to become questioned at the lower court levels and then at the U.S. Supreme Court. And I think part of that had to do with just changing attitudes about unions, seeing that unions maybe weren't great for everybody in the public sector. And in the Janus case, they reversed that requirement. And the premise was the U.S. Supreme Court looked at public sector unions and saw that not everything that everything that they did, really, even collective bargaining, was inherently political. That's because, when a union sits down, say, with a school board to do collective bargaining, they're going to be dickering over terms that would require the school board to make very important political trade-offs. Trade-offs between, for instance, paying teachers more and bringing new computers to the classroom, or providing healthcare benefits on one hand, or bringing in absolutely, completely new support staff to help with the teachers on the other. So these are all inherently political decisions, not necessarily partisan, but political. And to require a non-member who didn't want anything to do with the union to subsidize that kind of behavior, that kind of speech with their money, would be a First Amendment violation. Now that would have many practical ramifications for public employees. One of which was that many public employees had the economic freedom, to decide not to become a union member and to forego paying or subsidizing the speech of the union. That was in 2018. So things have been a
Right.
little different since then.
Got it. Well, I guess one other thing to talk about, since it is worth going into a little bit of the history here. You know, the idea of private sector unions is kind of well known to Americans. Some of the working conditions historically in places like coal mines, et cetera. Though those are well documented, and there's books written about them and the reason for private sector unions. I think they have a lot to be said for them in terms of at least the historical context. But how about government employee unions, which are the focus of your report here? I would count myself among those who don't believe that government employees should be able to unionize in the first place. So
Mm.
we're kind of talking about a report here that ranks states based on labor laws that at least this crazy libertarian radical, referring to myself, doesn't even think should be in existence. So are you basically in agreement with that, or what's your take on the status of public employee unions in the first place?
Well, you're in good company, Paul. They called Joe Biden the most union-friendly president, or most pro-union president since FDR. Well, FDR believed that there should be no such thing as public sector unions. The idea, as he understood it, was to give workers, unionization in general. The idea is to give workers a collective action, a collective body that they could counteract a private sector management. But in the public sector, private sector management is essentially taxpayers, public officials and taxpayers. And to give public employees the right to unionize against taxpayers and public officials is going to, result in a lot of problems. So that is exactly what's been borne out as a policy matter. Unionization of public sector employees, if you're going to do it, is going to come with a lot of problems. I think that the best way to respect employees is not to unionize and to adopt a different kind of system for managing public employees. Um, but I'll also say if you're going to have it, if you're going to have public sector unionization, you got to do it well. And that's really what this report is about. It's about everywhere from Alabama, which does not unionize public employees except for firefighters, all the way to California, which seems to unionize everything under the sun, including legislative staffers. So that's the real focus of the report. Let's work with what we have. I may be as libertarian as you are, Paul, but we also obviously have to engage with the real world here, and so that's what the report is about.
Well, fair enough. And let's go ahead and take on the report. So, um, this is the fourth edition, and how often do you produce this document?
We do every 2 years.
Okay. Uh, and let's go right to New Mexico. We get an F. Big surprise there. We're normally a state that, or no, is that a D? It looks
Yeah,
like
don't speak too quickly. You got a D
D
minus.
minus. Yeah, all right. We're kicking butt and taking names here in the land of enchantment. Yeah, some of the colors are a little tough to pick up on my computer screen here. I do see we are a deep shade of blue, which separates us slightly from California, Oregon,
Uh-huh.
and Washington, as well as Illinois. And so, it's no surprise that New Mexico is not, doing particularly well on this report. So let's talk about what you guys look at in terms of some of these, variables that determine whether states are ranked highly or ranked poorly. And who is your top performing state?
So we have a few A pluses this year. I'm gonna have to pull up the list here, but
I see Texas, Arkansas,
yeah.
Tennessee, North Carolina, South Carolina, Georgia, and Indiana. Those look like, and I realize that
Yep.
there's not always on these kinds of things, it's either a yes or a no. You have a certain law in place or not. But uh, yeah, let's work through the variables.
Well, the reason that we grade and have like an A plus, for instance, versus an a D minus instead of a D, is that there are so many aspects of labor law that go into play here. But I'd say the basic point that we're making here with these grades, we're distinguishing between very small differences in policy, but
Hmm.
collectively, the policy is either pro-union or pro-worker.
Hmm.
And what I mean by that, and so an A plus would be more pro worker. And what I mean by that is that employees need to have some direction and control over their own lives. What very pro union states do is they hand a lot of that power over to union officials. So unions often conflate the two ideas, assuming that every time a union gets power, that power is filtering down to workers. But the reality is, and this is especially true in the last 10, 20 years, unions who are accumulating more power are doing so at the expense of workers, not for workers. So, given the variability in policy here, we had to really count points for each state, and there are some states on the A plus range that either give public sector workers, extreme authority under their own employment. And then on the other hand, with the Fs, you've got these states like California, Oregon, Washington, Illinois, who have thoroughly unionized and then handed all the power to union officials. One example I'll give you that's a fairly recent trend in labor law. A lot of these F states did this kind of thing over the last few years is hand over employee information to union officials for purposes of organizing and even dues collection. So they'll take the state or the local government will take employee data like their names, home addresses, cell phone numbers, personal email addresses, even social security numbers, and by statute hand over that information to union officials so they can use it to contact that person at work and at home and send them emails, do it by various means, emails, text messages, all that stuff. It's political solicitations. It's also membership solicitations. And I've got to say, workers, they have the freedom to choose whether to become a union member or not. They don't need additional pressure from unions to do it.
Right. Yeah, and I'm uh, seeing some of these legal, these history kind of context issues when it comes to New Mexico and the
Mhm.
way you write up New Mexico's Public Employee Bargaining Act and the specifics here in New Mexico. Now, as you say, we're a D minus, not an F. We're slightly better. But one of the things that you really look at, and we've used it for years, is the 2010 Yale study about collective bargaining, specifically relating to school districts. And
Mhm.
you may not know, David, but New Mexico, in the most recent NAEP, National Assessment of Educational Progress, we came in dead last in every major category. So fourth
Mhm.
grade reading, fourth grade math, eighth grade reading, eighth grade math, we were dead last. That's 52nd in the NAEP after the District of Columbia and the DoD schools. So talk about how uh, this Yale study um, impacted public employee unions, but also impacted New Mexico's education system.
Sure, I'll do my best. So I'm not an expert in New Mexican history or in labor law in New Mexico. Maybe that gives me a unique perspective on it because when I started opening up the books for purposes of this study and looking at New Mexico, I found a really interesting state, a state that was full of contradiction, a state where there had been major battles over this stuff.
Mhm.
Um, before I even got interested in public sector labor, and there were a lot of lessons to be learned. So yeah, the Public Employee Bargaining Act is the statute on the books now, but it hasn't been on the books for nearly as long as state labor, collective bargaining laws have been on the books in other states. It's a relatively new arrival. So in 1992, well, sorry, it was actually enacted in 2003, but there was a predecessor to it in 1992. And in 1992, you had a study actually at Rio Grande Foundation that documented this. There was a bunch of warring attorney general opinions over the years that
Mhm.
started a very long time ago with, I believe it was insane asylum employees looking to organize in New Mexico, and the attorney general said that they could not unionize and that they could not even become members of the union. Well, there were other attorney general opinions throughout the years. The attorney general would say you can become a union member, but you can't organize. And then some attorney general opinions that said you could not only become a member of a union, but you could also organize and collectively bargain. This went back and forth for years. And then in 1992, New Mexico enacted its first public sector unionization statute. So it would have been the predecessor to the Public Employee Bargaining Act. And that unionized employees, including teachers. And then but there was a sunset clause so that it expired in 1999. And for a 4-year period from 1999 to the time that PEBA was enacted in 2003, there was no such thing as collective bargaining. Now, there were some collective bargaining agreements that may have been respected or in place for a period of time, but there was no state regime that would have mandated public sector bargaining in school districts. So what that did is give a unique opportunity to study the effects of collective bargaining on public education. Because here you've got 3 different examples. You've got unionization from 1992 to 1999. You've got lack of unionization from 2000 to 2003, and then in 2003, you had public sector unionism once again. So the Yale study that you referred to was done in 2010, and what they did is take a look at the collective bargaining impact on student achievement. And what they found was it was a very interesting result to me. They found something very nuanced. High achieving students actually performed better under collective bargaining. That is, while teachers were unionized and working under a collective bargaining agreement, these high achievers did even better. But what they found is that lower performing students did not, and lower performing students did much better in that 4-year period without unions in their teachers' lives. Now, that we could come up with a lot of reasons for this, and the Yale study itself tried to come up with some of them. One of I think, the prevailing theory that they came up with was that without collective bargaining, then schools were allowed to quickly re-staff in certain areas, reallocate resources, and help those poorly achieving students get better. Under a collective bargaining regime, on the other hand, you've got teachers who are entitled to certain things, entitled to a position, maybe even entitled to a way of selecting students, or a way of minimizing the any changes to the classroom, so that the school district can't respond to some of basically an emergency within their student achievement. So it is news to me, Paul, that since then it sounds like New Mexico has done even worse with education, and that would be consistent with what Yale has found and theorized as to in that study. Very, very interesting state.
Yeah, it is an interesting state, and you did a very good job of kind of explaining the ins and outs. So, kind of just summarizing the situation is that the expiration of collective bargaining allowed the governor and the state leadership to incentivize those high quality teachers to go into tougher environments, tougher classrooms, and really bring up the lower level students. Whereas with the collective bargaining in place, because you couldn't provide those kinds of incentives, that you wound up with a education system that suffered ultimately. Obviously, a certain number of higher performing students did even better with the better teachers that they were able to have, because there was no incentive structure in place, no incentive structure allowed to be in place, thanks to the collective bargaining law that kept those kids there in the classroom. And I would say that the NAEP test that we're talking about in 2022. Now, New Mexico has always struggled with education outcomes. This is nothing new, but we've never been quite at the very, very bottom like we wound up in this 2022 nation's report card. But that's thanks in part to COVID and COVID lockdowns. And you think of your prototypical blue state as a California or a Washington or an Oregon there, especially with the large populations packed into places like Portland. New Mexico is, as you say, a very, very unique blue state. We are a rural blue state with lots of people in fairly rural communities that don't have great internet access, that come from minority backgrounds, and just didn't have the wherewithal to take on the role of educating their kids during COVID. So the next NAEP scores that come out will be very interesting to see. I think they should still be out sometime this year. We'll see when that happens, but we'll see if New Mexico kids have recovered at all. The problem being that we've also seen a outflow of young people from the state of New Mexico. People voted with their feet and moved places like Texas, and other people have taken their kids out of public schools, including my own family, which has moved to Catholic schools. So you've got a lot of challenges. Any other aspects of New Mexico in particular stick out relative to kind of the other states that you looked at? Obviously, we are a blue state. We show that by being a D minus. Not all Democrat controlled states are at the very bottom, but generally speaking, there's a pretty strong correlation, because one of, if not the single biggest kind of partners in the Democratic Party coalition is the public sector unions.
Well, New Mexico was one of the states that adopted some of these access to public employee pro-union reforms that allow unions to obtain employee data. Not only that, but New Mexico recently gave union officials acts like in-person access to public employees, so that unions have guaranteed time during union orientation when new employees are hired. And if there's no union orientation, perhaps because of COVID, then they get in-person access to each public employee for a minimum of 30 minutes. That's some pretty hardcore recruitment time right there for new employees. In addition to that, some of the union officials get that right unsupervised, and they can use public email systems to make contact with them. They also get use of government buildings for union purposes, and they don't have to pay for this kind of stuff. Um, just for reference, one of the things that Trump did when he came into office was issue an executive order that would end some of these kinds of things. Now you see it popping back up in states like New Mexico, where unions want to use government buildings for union purposes, and then use the public email system to make contact with employees. Something else that was really unique about New Mexico, there's a lawsuit that, in my view, repairs some of the imbalance here between public union officials that I've been talking about and employees. So if an employee is underserved by their public sector union, they really don't have much they can do about that. Not in New Mexico, anyway. There are states that have addressed this problem in other ways, but what New Mexico does have is a pretty robust private right of action called the duty of fair representation. It's sort of like a fiduciary duty. One could go to court over this and sue your government officials. They can actually go straight to state court in New Mexico to file one of these against their union officials. Something I've helped public employees with in other states as an attorney, and something that if you've got a public interest litigation firm that can take this kind of thing on, or a pro bono attorney who can do it, there may actually be some fruit that comes from a public sector employee, a teacher who's been misserved or disserved by their public sector union officials, taking them to court over it. And the New Mexico Supreme Court actually recently decided that punitive damages may be available to litigants who are suing over a breach of the duty of fair representation. It's a very interesting sort of, you'd expect it to be all bad. And maybe this is part of why you got a D- here and not an F. There are some avenues for change in New Mexico. And unfortunately, just most of it is done through the court system.
Yeah, no doubt about that. It's been a while since we had a legislature that was able to actually pull back on some of this, or been willing to. We've had attorneys general, and like you said, they've gone back and forth. Some governors that have been good on these issues, but the legislature ultimately, I mean, correct me if I'm wrong, would you agree that the legislature is ultimately the arbiter of these public sector labor laws, and how generous they are to the unions, or how well they protect taxpayers? Would you agree with that statement?
Yes, oh, absolutely. This job is done at the legislative level with some guardrails, some really important guardrails from the courts. And there are some some federal court cases that are going up to the U.S. Supreme Court that may actually tip this in favor of the courts over the legislature. The reality is, as we described with even with FDR, is that the First Amendment is really implicated whenever a state legislature hands over too much authority to private entities like public sector unions. And to the degree that they force employees to give up information or give up some of their rights, the First Amendment may have something to do with that. And so there may be some court cases that change this.
Now, you mentioned FDR a couple times. Now, my understanding is that FDR, while very pro private sector union, was not as inclined towards government employee unions. And he wrote that famous letter, and there's that quote about the laws and the application of collective bargaining laws. And I'm paraphrasing, of course, here, but the collective bargaining laws do not translate easily from private sector unions to public sector unions.
Right.
Uh, could you shed some light on that? Am I kind of underestimating FDR's friendliness with public employee unions, or was he genuinely did he have the same concerns in some ways as you and I do, or where was he in terms of these issues?
Yeah, he did. I mean, he could see what would happen if you invited unions into the public sector. But I mean, here's how it works. A union comes into the public sector. It's totally unlike private sector in the sense that they have something they can do to change the person with whom they're bargaining. So in typical collective bargaining, you've got a union that's sitting across a table and negotiating terms with an employer. And if that employer is in the private sector, you've got a business owner, you've got a factory owner, and someone who is out in the private market trying to sell products. And they're constrained. They're constrained by the market itself. In the public sector, there's no such constraint. When the union sits across from somebody at the bargaining table, that person, they're getting their money from taxes. And so if they can't really say they're running out of money. Business governments, they can in practice go bankrupt, but they can always raise taxes. So when a union is arguing for more money, better pay, whatever it is for their workers, what they're really doing is pushing the policymaker to increase taxes or to make really difficult policy trade-offs that would filter more money from other public projects to the union. Worse than that, the union can get involved in politics, which they've done, and can change the person at the bargaining table by supporting someone else for reelection. They do this even at the presidential level. Kamala Harris is going to come in if she wins the election, and she's going to appoint people who are going to be across the bargaining table from unions. Be very, very different if Donald Trump were to win the election and appoint his people to sit across the bargaining table from the unions. It's just a completely different thing. So unions obviously are going to put their money behind someone, especially at the local level, like school boards. They're going to put their money behind someone who is going to be more favorable to them at the bargaining table. Now, when I say that, I don't mean some workers might hear, well, that sounds pretty good for me. I'd love a better deal. Maybe unions should be involved in this kind of rent seeking and should get someone elected who will give us more money. That's not exactly what I mean. I mean that unions will get someone across the bargaining table who's friendly to union officials, not necessarily to workers. The most valuable things that a union secures at collective bargaining, as far as it's concerned, are things that are good for the union and help the union run. So we're talking about things like payroll deductions to take union dues from people out of their paychecks, something that New Mexico has. We're talking about things like release time, the idea that that government employees can leave government employment and go work for the union full time while still receiving pay and benefits from the public employer. Something that's really big in Arizona and has just been shut down by their state Supreme Court. So these are the kind of things that don't necessarily benefit public employees, but definitely benefit the unions. And the unions, frankly, would be crazy in this environment not to get political and to pick the person who they're bargaining with. That goes to the very heart of the problem here.
Got it. Well, let's shift gears a little bit and look at some of the top performing states, because we've talked a lot about New Mexico and some of the bottom dwellers here in your report. It is worth noting that not all states allow public employees to bargain. Now, is that the case for all of your top performers? You have Arkansas, Georgia, Indiana, North Carolina, South Carolina, Tennessee, and Texas. So, of course, neighboring Texas, one of the states that we really follow here in New Mexico, albeit from a bit of a distance, because they are typically doing a lot of things right. We're typically doing very few things right in New Mexico, certainly on this particular issue. But I just want to make clear that it is not unheard of in this country for states to not allow public employee unions to operate at the state level, basically no collective bargaining. So talk about that. Why is that the golden standard? Obviously, we kind of hit that at the top, but go into a little more detail on it.
Well, it's not necessarily. So some of these states that received A pluses did, you know, their score was boosted in part because they chose against collective bargaining as a means to deal with their employees. South Carolina, for instance, good example. But Tennessee has adopted something different. They call it collaborative conferencing. It's not collective bargaining, but it does allow public employees to bargain in a sense, or at least discuss the terms and conditions of their employment on an official, regulated basis with their employer. Under Tennessee's model, teachers will fill out a survey that indicates that they want to engage in some sort of collaborative conferencing with their employer. Basically, they want to revisit the terms and conditions of their employment. And then they select someone who they feel would be a good representative for how they feel about their employment. It can be a person, it can be an individual, it can be an entity, it can be a union. So unions end up having some role to play there, but there's basically they each get sort of representation on a committee that discusses terms and conditions of employment with the employers, and they come to agreement in a memorandum of understanding on the new terms and conditions for teachers. It's a good way to involve, sort of like a staff congress for many colleges. It's a good way to involve employees and to get their take, if not directly, through representatives who have a direct take on things. And so, I mean, that's another way of doing things that's not completely without union involvement.
Fair enough. Yeah. Anything else that we should kind of learn from some of these top performing states? I mean, obviously, we have a long way to go here in New Mexico, but the journey of a 1,000 miles begins with a single step. So maybe it's not the A plus states, maybe it's other states that have moved in a more positive direction. I know West Virginia is another state that's now an A state, so maybe that's a little more realistic, a state that traditionally comes with a lot of especially the private sector, coal miners unions and whatnot. But West Virginia has obviously done a lot right in recent years when it comes to public sector unions.
Well, here's something that West Virginia could do to go from A to A plus, and it's something that took Florida from a C to an A over these past couple years. They could adopt something called recertification. So recertification is a concept that came from Wisconsin, also heavily unionized state for many, many years. If you introduced it in New Mexico, it would make all the difference in the world. Recertification basically says that unions have to run for re-election. If not on a periodic basis, maybe there's some trigger. Like in Florida, if membership in the union falls below a certain threshold, then the union has to stand for re-election. There are only 3 states that have adopted this kind of reform: Florida, Iowa, and Wisconsin. But in each state, it's made a huge difference. It seems only natural that a union should have to run for re-election on a periodic basis. In New Mexico, like many other states, including Pennsylvania, when a union gets a certification to represent employees, it basically it presumptively holds that status forever. And that's a travesty for many employees, because unions tend to fall out of favor, especially when there's no pressure to make them adequately represent employees. So there's no competition whatsoever. Many of unions have held that status since the 1970s in other states. In New Mexico, it would have been probably as soon as 2003 with the new PIBA law. But unions retain that status for a very long time, and by the end of but at this point, there are many public employees who have never had a chance to vote on the union that's representing them. The only way to get them out under current law is something called decertification. It's sort of like a way for them to band together and then to vote the union out. But there are huge collective action problems with that formulation. So recertification solves those by requiring that there be regular re-elections for the union, and requiring the union to basically prove that they still have majority status and are representing most of the employees in a bargaining unit. That would make all the difference in the world, Paul, for people in New Mexico, because then public employees would have the chance either to retain their existing union if they're popular, to replace it with a different union that they would prefer, or to kick them out entirely and represent themselves.
All right. Well, we're about out of time here, David. So, anything else? I'll make sure that there's a link to your study in the show notes. And I'm also going to write up a specific post about this report because I think it's so important. And New Mexico could do so much better. But any other last thoughts you have for us?
Two last thoughts, Paul. So one is, collective bargaining and public sector unionism isn't the sexiest topic in the world. But I'll tell you what, whatever you care about in state policy, whether it's education reform, whether it's taxation, limited government, public sector unions are behind that. Public sector unions are pushing for status quo when it comes to education. They're pushing for larger taxes. They're looking for larger governments. So you should care about public sector unionism because it ends up being the feeder for a lot of these issues on the left, and really is the enemy of all that's good on the right. So you should care about that. Second thing, we do other reports on this topic. One of them received a lot of attention is on public sector union involvement in politics. We put out that study last year in December, and we'll do it again next year. It tracks public sector union spending in politics, not only using PAC dollars, but also the membership dues that people pay them. That I think makes the case, along with this report, that states that are left for political reasons, not for policy reasons, and states that are strongly pro-worker they're pro-worker because they have the freedom to do so. Their governments are not beholden to public sector unions. So check it out.
All right. Well, thank you very much for your time here, David. This is a great contribution to maybe not the sexiest issue, as you say, but one that does impact all aspects of our lives. And I think it's safe to say New Mexico's education system, while we're off supporting the ideas of school choice and education accountability, if we didn't have these kinds of collective bargaining laws, we could also do something for those most challenged students and improve our overall educational outcomes. So, unrelated to, in some ways, at least apparently, the topic, but when you dig down into it, you realize how critical this public employee union thing really is. So, appreciate your time today and appreciate all the research that went into this excellent report.
Thanks for having me. Had fun.
All right. Thanks for listening to this week's episode. Find all episodes at tippingpointsnm.com or at the Rio Grande Foundation's YouTube channel. Subscribe to the show at Apple, Stitcher, or tell Google Home to play Tipping Point New Mexico. Thanks to Path 3 Marketing for producing this show.